We have an appeal, we have a cross appeal, we have two appellees at least. Appellant, if you wish to reserve a portion of your time, you're free to do that, but you'll need to keep track of your own time at the podium. Cross appellant, if you wish to reserve time for rebuttal argument, you're free to do that as well. But that will come out of the 20 minutes sort of as well, and how you allocate your 20 minutes I'm agnostic about, other than it is 20 minutes for both appellees and then the cross appeal. And again, you'll need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask everyone in attendance to make sure that your cell phones are off. That way we will not have our proceedings interrupted and we will avoid embarrassment. We've read the briefs, we've conferenced the case. We'd encourage you to keep that in mind as you present your arguments today. Our proceedings are being recorded and will be posted to YouTube. So please, as you begin your argument, tell us your name and the party that you represent. With that, Mr. Lasota, you may proceed.
Good afternoon, honorable members of the court. I am Timothy Lasota here on behalf of the plaintiffs, appellants, Voice of Surprise and Quintus Schultzka, and may it please the court. I'd like to reserve 3 minutes for rebuttal, but I understand that's my job to stop talking at the 3-minute mark. The first thing I'd like to start off with is, obviously we've got this power of referendum in the Arizona Constitution. We have different statutes in regards to how it's exercised. Now one of the things we have is the city of Surprise saying they're now the gatekeeper to this right. And I think that's something we really need to give some thought to. And I think we need to question, if they're the gatekeeper, is there going to be a gate anymore? I think this case kind of shows, it's going to be very difficult. Simply because, we have a situation here in which someone comes in and does what they're told, gives the forms what they're told, and is issued an official serial number. Now, I know the other side keeps saying, look, you can't rely on the advice of an election official. Since when is an official act advice? It's not. An official serial number is an official serial number. I mean, to summarize the position of the city of Surprise, that we got to have strict compliance, but we have to issue the serial number to determine whether we should have issued the serial number at all, which I think is very much a fallacy. I think in terms of the job of the city clerk, I think, is well-defined, and it's well-defined in 19-121.01. You've got 14 steps there, right? I mean, there are a lot of words in that statute. 14 steps, you do this, you do that. If there's no serial number on it, you take the whole petition out, right? That's objective. That's something that city clerks can do without sort of compromising their neutrality. It's either there or it's not. The signature's either there or it's not. Those are fairly objective criteria. In fact, I would say they are objective criteria. I mean, this vast new role.
What are we supposed to do then with the statutory requirement about what the application needs to contain? And it is one of those statutes that, although targeted to the Secretary of State for a different kind of referendum, applies here. And it actually kind of provides specificity about what the application needs to include.
Yes, Your Honor. I think in this case, I think that either the application is rejected or the application is accepted, and then a private party, if they want to challenge that, they can go and challenge that. You'll notice that didn't happen in this instance, at least not until less than 24 hours before our trial, when the real party in interest filed their cross claim, which I thought it was 2 days, but I was reviewing everything. It was like at 2:30 on the day before the trial. So, and they raised these new issues and sort of inserted themselves as and I don't think properly so. I think they were required to sue. You hear this business from the other side about how, well, if you accept my argument, nobody has a right to challenge any one who violates laws with regard to petitions. That's not true. They have a right in 19-122C. What they did, it says any person can challenge the validity of a referendum or initiative or seek an injunction. They try to get the city of Surprise to do their dirty work, is what they did. And in doing so, they took the chance that, frankly, they put themselves in a lesser position, I would say. I still don't think they had a great argument, because if we go back to basics here, the whole thing about how you have to include the ordinance with the application, it's a futile act. I mean, the city tried hard to find a reason for it, but they got the law wrong, of course. They sort of mistook.
So if they had attached the statute or the ordinance but hadn't listed it in the application, that would be okay too, because, you could figure it out, basically.
Your Honor, I think that if they've attached, the big deal is what you hand to a voter, right? And you hand to a voter something that spells out what you are referring, and that goes in the body of the petition sheet. You don't tell the city clerk and at the city clerk's desk what you're referring. You tell them, you put it in the petition, because everyone who signs it, all 5,432 people who sign, say, I want to refer this. And that is the part, look, if I only dislike a certain part of that, that's the part where you say, I'm referring section 1 of SB 1232. It's not in the, and obviously what they say in their brief, if you attach less than a full copy, that's what they suggested, right? Well, you might want to attach less than a full copy of the title and text. Well, then all of your petition sheets will get disqualified, because the statute specifically says you have to include the full title and text. And I'm sorry.
Is your argument that they have to accept no matter what? Or is your argument that if they accept it, then they don't get to revisit it, and that they should check it first?
Your Honor, the argument is that once they've issued an official serial number, I think that task is done. I think the proper course of action, if something is facially lacking, is to reject it. And I think that there's the notion that Leach says you have to accept it.
So how long do they get to figure out whether it's facially lacking? I mean, does it have to be the clerk at the desk, or can they say, thanks for giving this to us on the day of the deadline, but we're not going to get to it until 3 days later? You can fight about whether it's timely at that point, but we got to see if it's appropriate.
Your Honor,
Does it
I
have
think
to be at the
that's
desk?
Your Honor, I think that's an interesting hypothetical, but I think at some point they've issued the official serial number, and that's that. And maybe 3 days, maybe that would be okay. I have to review this. But what other cities will do is they'll say, I'm going to review this. I'm not going to issue an official serial number, and you'll hear from them a day later. If they want time to review something.
No, completely.
If they want time to review something, then, give it, they can review it, and then, it's a short form. It shouldn't take them forever, and there are statutory requirements in terms of issuing a serial number, so I know that. But others won't issue it right away, or they'll say, look, the clerk's not here, I don't have authority to issue this. And I think this is a good point to segue into Leach v. Reagan.
Before you get to Leach v. Reagan, I want to hear from you on Leach v. Reagan. What you describe obviously didn't happen, and that's one of the reasons maybe why we're here. And we'll hear from appellees as to whether that's possible or not. But your suggestion that a city clerk simply refused to accept the application, is that really the law that Arizona would want? And let me give you an analogy, and it's hypothetical for this case. These days, I think and hope, when a deputy clerk at a court sees a document that's not compliant, they will accept it, maybe with exceptions, but they're not empowered to just say, no, thank you. I worry, because some of the concerns you raise are possible politicization of requests for referenda serial numbers, if there was acknowledgement that a city clerk could simply reject an application. I would worry about that.
Well, Your Honor, I think they can reject a facially invalid submission, and I think Leach v. Reagan actually has a point on that.
So what if they reject one that, in your opinion, is facially valid,
Then
They
you,
keep saying, no, we're not going to take it. I mean,
That's what I worry about, and there's no record that you tendered it because it's been rejected.
yeah.
well, Your Honor, you'd have a witness that could attest that it's been, I think that factual circumstance is much preferable to the one we have here, where they're waiting around, they know there's an alleged error in it, and they're waiting around until people collect signatures. If she would have said no, I would have said, why not? If she wouldn't have answered me, then I didn't submit it, but that's what I would do, and I would sue. And I would probably still have time to collect my signatures. So if she says no, the remedy right there is to sue. And let's examine what this means. This means that referenda are short, 30 days. You got 30 days. Initiatives can go on for over a year. So now we're going to have clerks that accept something for filing, and someone's out there collecting signatures for a year or more, and these signatures are invalid. The person, the clerk knows they're invalid. Why in the world would she tell someone how many signatures they need she's subsequently going to invalidate every single signature? So that's the corollary, is that people no longer have the right to rely on not advice, an official serial number, and they may be out there collecting for years and years. I mean, I think there are some interesting hypotheticals that are maybe that we could talk about, but I think that the facts in this case, I think she either accepts it, issues a serial number, in which case somebody's free to file some kind of action saying she shouldn't have accepted that. She exceeded her statutory authority.
Why is there a right to rely? I don't get where the reliance comes from. I can submit my application for a driver's license, they could accept it, and then figure out later I made a mistake and take it back. I don't get to say, I relied on you. There are a lot of things that we do and we submit to government, and there's no reliance argument. Why is there a reliance argument here for somebody who didn't follow the law? They didn't strictly comply. How do you get reliance under those circumstances?
Well, Your Honor, I think you get reliance, and whatever we want to call it, whether it's equitable estoppel, but I mean, you saw what the court said in Leach v. Reagan, and what they said is when you submit your predecessor documents, that's it, and once they issue the number, that's it, and it doesn't matter if maybe your statement of organization had an error. You've submitted these documents. Now, I know the answer to that is, well, that's the Title 16. Right? Well, that's the first answer, and that's exactly what the court said in Leach. But the next thing they said, but the litigants are clever, and so they say, well, no, it's not our private right. It's the Secretary of State's job to disqualify these petition sheets because of a failure to comply with the statutory and constitutional requirements. That's exactly, they argued essentially exactly what Surprise has done here, and they said, it's not just that we have a private right, never mind that, we lost on that. It's your duty. You have to disqualify these signature sheets. And the court said, no, you don't. If it were true what Surprise says, that they have to disqualify signature sheets for any violation, Leach v. Reagan would have been decided just the opposite. And then the Supreme Court went through and said, and examined the powers of the receiving officer and found power lacking in the Secretary of State in that case to do this thing, to reject something for this reason, or to invalidate signatures for this reason. So that's very important, because they went through and the statute they looked at 19-121.01, and they said, you don't have the power here. No, you don't have the power, you don't have the duty. And the other thing they said is, well, what in the world are we doing waiting around while people sign the petition sheet? And then we go back and then we examine whether I should have issued the serial number to begin with. I mean, the Supreme Court said it. I won't quote it, but it talked about disenfranchising people who signed the petition sheet. So, I think the bottom line here is I think Leach v. Reagan does control. I think there has to be some point in which the filing officer does an official act. This is something that, if they cancel your driver's license because they made an error, you go back in and you fix it, presumably. But this is a constitutional right, so I think that they issue the official serial number, and you know, the legislature already thought about this potential problem. You know, what about the person who just starts collecting before they get a serial number? Well, 19-121.01 tells us those signatures are disqualified. So the legislature has already thought about the serial number. They didn't make provision for a case in which the the serial number, I would say, never should have been issued or was improperly issued.
So your point is, once you get the serial number, compliance with the application, the organization is irrelevant?
Your Honor, I think that's right.
I just want to understand your position.
Yes, I think if they reject the serial number, that's a different thing, but once they issue the serial number, and I think even beyond that, we're sort of, that's before we even get into cases that have examined what strict compliance means. And they've said that it's not necessarily fatal. We look at the reasons for this requirement. And well, that's a very short conversation, because there is no reason. There's only one ordinance number 2022-018. As it happens, the clerk keeps it. There is no reason for somebody to hand a copy of that ordinance back to the clerk. So, I mean, you might even look at this, you know, and just thinking of it now, is this a provision if we're going to say if you don't attach it's totally different with an initiative. Initiative, it's your language. It's your law. Referendum, it's their law. And they're the keeper of the law. You know, is this...
So we just disregard what the legislature said?
Well, Your Honor...
I mean, that's what you're asking us, is to say, yeah, they said it, but it just doesn't matter.
Well, they didn't say it was fatal. They said if
They said strict compliance.
Well, they
That's in the
did, but
statute.
you said strict compliance first, and then they said strict
But
compliance.
they said it now. So you set that aside. It's a legislative
Right.
mandate now.
But in other places in the statute, they say if you don't do X, they're invalid.
And they also say if you don't do X, it's okay. You start to collect your signatures too early. That's okay. So why is it that we're here to say that the disqualification isn't appropriate? I just don't understand why that's not the appropriate outcome. Under these circumstances, strict compliance, which is, your big difference when you're looking at the Reagan case.
Well, Your Honor, there's Leach v. Reagan, and there's also the fact that, I mean, at the end of the day, this is a constitutional provision. We've had years and years of case law that says, look, they can pass regulations as long as they reasonably supplement the constitutional provisions. Well, how could we ever say that something that has no real independent, I remember one of the cases talked about independent reason. How could we ever say that, and it was a case where the people cut off the actual title and text before they turned in the petitions, but then they said that, well, they were attached while we circulated, so we're going to accept that. So
Isn't the answer to that question, because I know you're running short of time, do it right? I mean, that's what the legislature seems to have said, just do it right.
Well, Your
And then
Honor,
you can bring it.
I mean, if that's what we're going to say about rights, then, I mean, do it right. So how is something reasonably supplementing a constitutional provision if there's no real reason for it, but if you don't adhere to it, every single one who signs it gets their signature thrown out? I mean, I think if you want at base, I think that's your answer, is I don't think something that has no purpose and that if you violate it, you lose all your rights. I don't think that that's a reasonable supplementation.
Just so I'm clear, so in your opinion, from now on, nobody would need to really attach the copy of what they're trying to take to a referendum. That's just surplusage. Because if we rule that way, that's what the outcome. Take it to Secretary of State, don't attach a copy, because that's just not necessary.
Your Honor, I disagree. I think what would happen is somebody who's looking takes a look at that and they sue the filing officer and ask that serial number be canceled. That's what happens. You still have the private right of action under 19-122C, where private parties can come in and for any reason ask that your signatures get thrown out. So I'd like to stop now.
Thank you, Counsel. We look to this table. Ms. Ripper, Mr. Gross, who's going next? Okay, very well.
Okay, good afternoon. Ellen Van Riper.
I apologize.
That's okay. It happens all the time. Chief Deputy City Attorney for the City of Surprise. I'm here on behalf of all the city defendants, appellees. I would like to reserve 12 minutes of our time for Mr. Gross, so I will watch my time. Okay, we believe the trial court correctly denied the relief requested by Voice of Surprise. This court should affirm that decision. It was very well reasoned. And like the trial court below, this court should conclude that the referendum is not legally sufficient per 19122A. Again, that is the court's charge. It was the court's charge below to determine legal sufficiency. Same thing on appeal. Now, it's undisputed, and the panel has already recognized this, that Arizona law requires referendum proponents to strictly comply with all provisions of the Constitution and Title 19 that apply to exercise of the referendum right. Voice of Surprise would have you discard that to uphold what happened in this case. This has been case law in Arizona for over 40 years. Back in 2015, the legislature saw fit to codify the strict compliance standard for referendum. And the legislature says that those using the referendum process shall comply with those constitutional and statutory requirements. That's the entirety of Title 19. It's not, as Voice of Surprise would suggest, just 19121.01. As the proponents, it was their obligation, not the city clerk's obligation, for them to strictly comply with every single applicable provision of Title 19. They obviously didn't do that because they didn't attach a copy of the measure to be referred, Ordinance 2022-18, to the application for serial number.
Ms. Van Riper, let me ask you about that. Wouldn't that be kind of apparent when the application was submitted?
Mm-hmm. Yes, it was. I mean, there's testimony below from our city clerk, Ms. Aguilar, that she realized right away when she got the application from Candace Simpson on behalf of Voice of Surprise that she hadn't attached the ordinance to the application. And even though it had been provided to her, that's not disputed. The clerk fully performed her duties, provided them the pamphlet from the Secretary of State's office on how to exercise the referendum. She provided her a full copy of the title and text of the ordinance, so it had been provided.
Was the town clerk prohibited from saying, hey, you might want to look at this, it looks like something's missing?
Yeah, well, the difficulty is that 19111B mandate says shall, which is must in this context, that when the clerk is given an application for serial number and a statement of organization, she shall issue a serial number. In this case, the application for serial number had most of the required information. They filled it out, they put in identified their organization and the officers, they put in their 200-word description of the measure, but they didn't attach the measure to be referred, even though the front of this paper, this is IR 61, says it's attached.
But the town clerk treated it as a completed application, correct?
Well, she treated it as a sufficient application
Right.
in order to issue the serial number.
Wouldn't have done that. And I think there was even testimony about what if you just submit a blank paper.
Yeah, and that's not our case.
No,
obviously.
it's not. It's not.
Okay.
But are you arguing that the town clerk was prohibited from saying, hey, it looks like you're missing something?
Well, if she had done that, she would have been giving them legal advice, and that's not her role.
Is that really true? Is that legal advice?
I think it is, because it's a substantive requirement of the statute. You shall attach the measure to the application.
But don't you give that to them when you hand them the pamphlet that says, here's what you need to do? I mean, that information is part of what you're leaning on to say, we gave them everything they needed to comply, and when they didn't comply, it's not our problem. But we can say it when they come to the window to get the application, but we can't say it again when they turn in an application that, from the testimony below, was clearly deficient from the get-go?
Yeah.
Why is it prohibited the second time, but it's just fine the first time?
Okay, well, the first time they came in and they got the pamphlet and they got the ordinance. And they came back to submit the completed application. The record shows there was some interaction via email and text about what we need to do. And I don't think that the clerk can properly tell them, that you have to also attach this to your application.
Could she wink and hand back a copy of the pamphlet and say, you might want to read this again before you submit this to me? I mean, this seems kind of semantics about the fact that the city is saying we have to give them this information from the start, but we're strictly prohibited from giving them that exact information when they come back 3 days later with their completed application. Help me make sense of that.
Yeah, well, I think, that the clerk, as, the cases show, and the clerk cannot provide legal advice, and that would be giving legal advice to them, telling them, you have to also attach this. I mean, yes, it does seem harsh, but the cases and the law show that it's up to the proponents to do everything. It's up to them.
Can I follow up on Judge
Okay, sure.
Bailey's question? So, giving the referendum petition packet that says, hey, you need to attach the text, that's not legal advice. But if you were to receive an application that didn't have it and you pointed that out,
Right.
that would be giving legal advice?
That is correct, because by statute, her ministerial duty is to provide that pamphlet and to provide the measure to be referred, that they identify to her.
What's your best case for the thought, and I mean decision, opinion, for that for the thought that that's saying, hey, you might want to look at this again, is the provision of legal advice?
Yes. Well, again, because it is a substantive requirement.
No, and my question is,
Yes.
what if there's a decision by a court or a provision or
yeah.
anything that
Okay,
would support what you're
Okay,
arguing?
I'm not aware of anyone, Your Honor. I certainly could go back and look and send you something, but I just don't think that that's the role of the clerk. I mean, because the way the cases are, the duty to comply strictly is put on the proponents. The clerk administrates the process, provides the information, and it's up to them to decide how to complete this application for serial number and what to attach to it. And so Mr. Lasota suggested that, well, she should have just rejected it. Well, if she rejects it, then she would have to tell them why, which gets us back to providing the advice.
Can I jump in with a question to follow up on this?
Sure, certainly.
And trying to understand your argument. As I understand it, you're saying, look, by statute, we have to tell them what the law requires. This is the list the law requires, and the Secretary of State has created the checklist for you to follow. And we have to give you the statute. Here is your statute. Your argument seems to be it would really be the unauthorized practice of law for us to then go through and say, now let's take a look at the checklist for you. And we noticed you didn't put this in that was on the checklist. We noticed that you got this number wrong. That's when you're getting into legal advice. That's what people hire lawyers to do, is to make sure they've complied with the law. You're just, in what you're doing under, as required by statute, is providing what the law requires, not whether or not they've satisfied it.
Yes, and
And that's a distinction between what is complying with the law versus practicing law.
Yes, we agree, Your Honor, wholeheartedly with that. Now, I also want to address the argument about, the issuing the serial number somehow, preventing the clerk from then going back and citing an error, even when she knew about at the beginning. As we said in our brief, that this is an over-the-counter transaction. It's not something that is, where the clerk then takes it away to a back room, consults with maybe the city attorney, is this okay for several days? As we know, time is of the essence with referendum. It's a 30-day time clock. I don't think that she could have done that without getting a lot of protests by the proponents. And it is, and I think, Judge Goss already kind of highlighted the nature of this. It's over the counter, you submit it, it looks facially okay, but that doesn't mean we can't go back and say you did something wrong. And I guess the other part of the argument is, this application includes a lot of information, contrary to how it's been described. They have to, do that 200-word description. They have to identify their organization. They have to attach the form. And it has to be an 8-point type. So we expect the city clerk to go through and check all this stuff, exactingly, before giving it back to them.
And so are you saying that if we agree with what Mr. Lasota is saying, that somehow it's not, in this case, maybe it's easy because it's something she saw immediately
Right.
and knew was a problem, but
Right.
if we say that it has to be checked then you're asking them to do things that maybe you'd have your city attorney do, not the clerk who's taking the filing.
Yeah, correct. And so, and I think that also then goes to another, overarching theme of a lot of these cases is the courts want to see uniformity in application and exercise of the referendum. If we start picking and choosing, well, the attachment issue is okay because it was obvious, but we're not going to make the clerk then help them with their 200-word description. We can't go there. And the trial court recognized the slippery slope we start going down if we start requiring the clerk to help. And that's not what the cases
What's
say.
easy enough. It's not that hard to count and see if it's 200 words. So that meant maybe we can do that one, right? That one could pass. That's what I guess my point is.
Yes.
Yet everything could be easy taken in isolation.
Correct.
It's complicated when you have to look at everything on the board.
Yeah, and plus the 200-word description is not just counting words, it's also the substance. Is it adequate? Does it adequately describe the measure? The clerk is going to have to make that determination before she gives this back to them. Otherwise, she's forever stopped from rejecting the petitions. And that is the remedy, Your Honors. See, where am I at? Oh, I think I have to go stop. I'm going to stop for Mr. Gross.
Time goes fast.
I want to leave him time, and thank you. I enjoy your questions were very good. Thank you.
Thank you, Ms. Van Riper. Mr. Gross, and I understand you're wearing two hats today, and I appreciate representing or speaking on behalf of both cross appellants. Yes, so please, and if you wish to reserve some time, it's up to you, but I need to be quiet so you can get started.
Okay, thank you. Yes, I am stepping in for Mr. Artigue, who unfortunately has COVID. I want to address, first of all, following up on the discussion that you just had with Ms. Van Riper. It's our position that it really does, at the time of the application, really doesn't matter what the clerk did or didn't do. She wasn't obligated to give them legal advice, and it's their responsibility. Case law makes it very, very clear that it's their responsibility to follow the law. Whether she told them something, whether she didn't tell them something, ultimately it boils down to their responsibility, and they can't lay that off on the city clerk. I would like to focus my argument on the legislative-administrative distinction. There was a case that came down 2 days ago, which was Workers for Responsible Development versus City of Tempe. I would like to take a couple of minutes to try to distinguish that case because it came out on the opposite side of the position we're taking. A couple things about that case. The basic distinction between this case and what I'll call the workers' case is that concerned a development agreement. This case concerned a PDP called Preliminary Development Plan, which is basically a site plan. The court in Workers held that the development agreement was legislative for a number of reasons, none of which apply here. First, we had this overarching sort of view from the Florence Copper case that development agreements are a legislative action. So that kind of set the stage. Then the court looked at the various components of the development agreement to say that it was legislative. The development agreement went beyond the zoning because the city had argued that the zoning was the legislative act. The development agreement, what came after, just implemented that. But the court said, no, the development agreement went beyond the zoning. It created new policies. It addressed tax issues, it addressed sales and leases of the property, other things that went simply beyond land use. But here, our PDP did not go beyond the zoning. Instead, it complied with it. That was a clear finding by the city of Surprise. The PDP limited its uses to those in the PAD, and I understand some of these acronyms might get confusing, and I hope I don't misstate them. But again, the PDP limited the uses to the PAD, the residential, retail, office, mini storage. And the residential density, although the Voice of Surprise takes issue with the fact that there was no residential density in the PAD. In fact, there was, because the provision in the old code that they cite in their brief says that the residential density has to be within a range established by the general plan. that was within the old code. So sort of baked in to the PAD, the approval of the PAD, was that the density had to be within a range of the general plan. So the PDP merely picked a number from that range. In workers, the development agreement required a new PAD to determine the uses and densities. Here, the PAD was existing. It was already existing. That was the legislative act that determined the uses. PDP just implemented it. In workers, the development agreement that provided that it would benefit the entire city, so there was more of a generality. Here, the PDP was specific to Truman Ranch. In workers, the development agreement didn't reference the underlying zoning or say it was implementing it. That's a finding the court made. Here, the ordinance itself calls the PDP an implementation of the PAD and says that the PDP is consistent with the PAD. Again, the uses and other standards that are in the PAD, other development standards. And then the development agreement in workers provided for deviations from the zoning code. There are no deviations here. All uses and standards are within the PAD, and the ordinance in workers adopted that adopted the development agreement referred to it as a policy. There was a word in the ordinance that said there's a policy. That's not here. Instead, it was just an implementation.
Mr. Gross, just to be clear, what you have just, the argument that you're making on the cross appeal is an alternative theory on why the trial court, you believe, got it right.
Yes. And by the way, I join in Ms. Van Riper's arguments. Let me try to take a minute here because really at the bottom, they really have no answer to the Redelsberger case and the Price case and a case that was cited in Redelsberger called Sandblum versus Corbin. Redelsberger and Price and Sandblum were all special use permit cases, adoption of special use permit. But really the point is the same with the PDP, is that the use was already allowed by the zoning. And that's why those courts came to the conclusion that this decision following the zoning was administrative. And it's exact same thing here. The court in Redelsberger in paragraph 27 quoted the Sandblum case as saying, even though the permit special use permit may authorize a change in the use, it was already pre-approved sort of in the zoning, and as a result, the public's not affected to the same degree as if it were the zoning, and that's a paraphrase. Same rationale here, even more so. The PAD established the land uses, the retail, the commercial, the office, the residential. The PDP, even unlike Sandblum, didn't authorize any use, a change in any use at all. So we're even more administrative than in Sandblum, and to some extent Redelsberger and Price. It also, the PAD also established building heights, design standards, property setbacks, and everything. So again, the public here was not affected by the PDP, as in the case of the change in zoning, just as in Sandblum, and in the cases that followed it, including Redelsberger and Price. And can I reserve any more time for Ms. Van Riper?
You can for your cross appeal if you wish.
Okay, the cross appeal. I will reserve
Very well.
more of my time unless you have any questions. Thank you.
Thank you. Mr. Lasota.
Thank you, Your Honor. So very briefly, one thing I didn't mention is 19-122A says that if the petition is legally sufficient, the clerk shall be ordered to process the signatures. So where do we get from that to the application? We don't. One other thing is this legal advice, so the clerk said in an email, it's in the record, you need the statement of organization and you need the application for a serial number. Obviously, you also need the ordinance, but it's legal advice to say you need those three things, but not legal advice to say you need the two things. She said in an email, she didn't just hand us a packet, she said you need these two documents. So I don't know how it could be legal advice to say you need the third document. In terms of the form, it's a one-page form. And Leach talked about facial validity. They said, because that's one of the other side brings up, well, you know, if you have to investigate it, you got to do all these things, and they said, no, a facially invalid document will not suffice. And that takes us to the last point where the clerk here actually said she didn't notice the, she said she did notice. So I think it's a totally different factual pattern, and I think Leach tells us that under these circumstances that this suffices, and if somebody wants to sue the clerk, they can sue the clerk as a private litigant. I think a lot of the clerks, I think if they knew that when 19-1 or 1.01 passed, they'd have this massive new mandate, I think they would have been unhappy with it. Other than this, the surprise clerk, I mean, it's a difficult position to put a city clerk in, that now they have to look for any possible shortcoming in an application. The Leach court cautioned against that. The last thing I want to mention is, and I know that Mr. Gross tried to distinguish that, I think Workers' P or that case, but one case they cited was Fritz v. City of Kingman. And in that case, it said, in Fritz's case, the initial zoning law permitted 1 dwelling per acre. The rezoning placed her property in a new classification of 4 dwellings per acre. The change necessarily constitutes a new policy on the appropriate density of housing on her individual property. As such, it is a legislative decision. I didn't see that until yesterday, frankly, so I think that does support the argument that it is a legislative decision. Thank you.
Thank you, Mr. Lasota. Mr. Gross, for rebuttal for your cross appeal, you have 52 seconds if you wish to use them.
I was actually the counsel of record in both Redelsberger and Fritz. I guess I don't understand counsel's argument about why Fritz should support this case, because in Fritz, the Arizona Supreme Court simply held that the general plan is not legislation. So rezoning is. And that's what we have here, is because the PAD was the zoning. And in any development, approvals have to follow. Site plan, development plan, subdivision plat, building permits, construction drawings. Those are all implementation of the zoning ordinance, of the rezoning. So those are administrative. I think our case law is clear. Last thing I wanted to make is there was no reason for us to file a lawsuit in this case, because the city clerk had rejected the petitions. Mr. Lasota keeps saying, well, we should have sued. But we didn't have grounds to sue because we couldn't claim any relief. So it would have been meaningless for us to file a lawsuit to claim relief that the city clerk had, or the city had already granted. Thank you.
Thank you. And we take the cases as we find them. Counsel, we appreciate it. Let me also, on behalf of the court, thank you. When we did our scheduling order, you moved quickly to make time available for us. And particularly for an appellate court, that's not something we're always so good at. And I really appreciate you responding so quickly. We'll take you've given us much to think about. We appreciate your written briefs and your oral argument today. We'll take the matter under advisement. We understand there's some urgency here, and we'll issue a written ruling in due course in the comparatively near future. Thank you.